As such, his passing brought profound sadness to the court. To pay fitting tribute to the man, his life, and his legacy, our President, Honorable Mr. Justice Saunders, will address you. President Saunders.
Thank you very much, Madam Registrar. It is the case that mortal beings as we are, we all must die someday. And over the last few years, on each occasion I met up with Justice Pollard, he looked more and more frail. When I saw him last in December last year, he seemed to have aged considerably over a relatively short period of time. He was certainly more subdued. But still, Justice Witt, Mrs. Witt, and I had a great visit with him. It was therefore with deep sadness that I learned of his passing in New York some 9 months later. To say that I will miss him greatly is an understatement. I had, of course, known Justice Pollard well before we both joined this bench. Before the court was established, he had come through the region as an emissary of the Caribbean Community Secretariat on several occasions, passionately advocating for the CCJ and sensitizing the Caribbean public on the revised Treaty of Chaguaramas and the CARICOM single market and economy. But he and I became very close when we found ourselves selected as judges of this court. At the time, we were respectively the oldest and youngest members of that first cohort. We developed a warm, mutually respectful, personal, family, and professional relationship. We spent considerable amounts of time in each other's chambers. What united us was a love and passion for law and for promoting the best interests of the Caribbean community and the region in general. We saw aspects of the law from different perspectives. That was not unexpected. My vantage point is linear and comparatively limited as a law student, a litigator, and then a judge. He had been a teacher, a diplomat, a legal drafter, a regional public servant, an academic, before becoming a judge. Indeed, he became a lawyer when he was already a very mature man. And so we used to have these fierce intellectual debates that I found so very stimulating. We fought and argued about the role of courts and of judges in constitutional and legal interpretation, and about judicial activism in assessing the constitutional balance among the branches of government. He would often suggest that I and others advanced a notion of judicial supremacy. I denied that, of course. And I argued that sometimes I thought he was wedded to a notion of executive supremacy. Of course, either concept is anathema. And to be truthful, we may well have been caricaturing each other's views in order, good-naturedly, to score debating points. But after we indulge in these interminable polemics, we would repair in the evenings to his favorite watering hole in Port of Spain, Jenny's on the Boulevard, where over a plate of hot wings and suitable libations, we would discuss cricket and Caribbean and international politics. Duke was always curious about the society in which he lived. I remember in those days, there was a very, very popular night spot and discotheque called Zen, just off the Queen's Park Savannah. One day out of the clear blue, he asked me whether I'd ever been to Zen. He had heard a lot about it, and he wanted to go and check out the place for himself. He suggested that we could both go. I picked him up, and so we did one night. As we approached the ticket counter, it was immediately apparent to me that something was amiss. The patrons lined up behind us were dressed in the most bizarre costumes. I cannot imagine what the lady selling the tickets must have been thinking when these two middle-aged men presented themselves for their tickets to enter. She looked at us up and down and tried unsuccessfully to suppress a giggle. She said, "Gentlemen, do you realize it's Halloween and tonight we have a Halloween party?" Duke was not amused at what he thought was a slight. He was very sensitive to any kind of slight against his person. To cut a long story short, we went into the nightclub. We bought a drink. We looked around for about half an hour, staring well clear of the young witches and wizards having fun, before I dropped him home well past his usual bedtime. He was a prolific writer. He wrote several books on international law and in particular on CARICOM. It was he who, as far as I'm aware, coined the phrase that accession by Caribbean states to the appellate jurisdiction of the CCJ completed the circle of our independence. It was the title of one of his books. Not enough persons know or fully appreciate the role he played in drafting the revised Treaty of Chaguaramas. In the early years, when there was little litigation before the CCJ and we judges had a lot of time on our hands, we encouraged him to convene these sessions in the judges' lounge, where he would take us through the various chapters of the revised Treaty of Chaguaramas, article by article. In what respects does a provision parallel or differ from the EU treaty? Where are the problem areas that will require the exercise of discretion in interpretation? What was the thought that went into the inclusion of a particular provision, and so on and so forth? Duke was one of the delegates who met in Vienna in 1968, 69, I think it was, to conclude the drafting of the Vienna Convention on the Law of Treaties. And so we all benefited tremendously from his knowledge of international law, his guidance and experience, especially as most of us were common law judges and had little prior practical exposure to international or regional economic law. He was a fluent speaker with an elephantine memory. Invariably, he delivered his speeches without notes. He could speak for 40 minutes and more, citing details of case law and treaties without a scrap of paper in front of him. He knew the revised Treaty of Chaguaramas like the back of his hand. Once, when we were in Belize to do some judicial training, he gave a lecture on the treaty to the Bar Association. As he rattled off and explained this and that article, without notes, of course, a Belizean lawyer I know, and who was in the audience at the time, shared with me afterwards that she was convinced that Duke's recall of these various articles could not be so powerful. And so, as Justice Pollard moved easily from expounding one article to the next, she told me she began to write down the various articles he cited and what he was saying the articles stood for, because she was not convinced. During the break, she got a copy of the treaty and compared her notes with the content of the treaty. And to her amazement, every single citation was spot on. Duke committed to memory not just important passages that he had read, that he found interesting, but if, for example, the passage was from a reported case, he would tell you the volume of the report, the name of the judge, and the page on which the passage could be found. So, for example, he was particularly perturbed and exercised about a passage in the case of Thomas and Batiste, where Lord Millett, writing for the Judicial Committee of the Privy Council, stated that, and this is the quotation, by ratifying a treaty which provides for individual access to an international body, the government of Trinidad and Tobago made that process, for the time being, part of the domestic criminal justice system, and thereby, temporarily at least, extended the scope of the due process clause in the Constitution, unquote. Duke was terribly perturbed, as I would say, about that quotation. And when he would he referred to Lord Millett's statement as, and I quote, a novel juridical postulate, unquote. After Justice Paul had retired from the court, his sons were still at school in Trinidad, but Duke was adamant that he should return to Guyana to contribute to the development of his native land and to give back to that country some of his wisdom, knowledge, and experience. And he did so, almost right up to the time of his death. Of course, he returned to Trinidad often, and at least every year's end, he and I would get together at his home or mine or at Jenny's, where we would resume our ardent legal jousting. On a few occasions, he entertained us judges at his home at Maraval. He was a simple man, devoid of any ostentation or affectations. There were two things I know about him, which he was very uncompromising about. The first was a principle that he should never reside in premises for which he or someone on his behalf was paying rent. Literally within a day or two of coming to Trinidad, he made sure to fix that issue. The second thing he never minced matters about was his writing style. Sometimes Duke would write a passage and it would take me 2 or 3 times to fully grasp the meaning of that passage. His writing was always pitched at an extremely high level. I understand that some of his students, when he went back to Guyana to teach, begged him to simplify his writing for them. And Duke's logical response was to challenge them to get up to his level and not expect him to descend to theirs. When Justice Pollard passed away on the 13th of September last, Guyana and the region lost a true champion. I lost a dear friend. On behalf of all the judges and staff of the court, the members of the Regional Judicial and Legal Services Commission, and those of the CCJ Trust Fund, I extend deepest condolences to all his family members and loved ones. We extend our sympathies especially to Mrs. Pollard and the younger children, Yuki, Nathaniel, and Chad, who were all so well known to us at the court. I know too that Mrs. Ramit, who was his executive assistant for quite some time, and Mr. Hart, his driver, while he was with the CCJ, would particularly want me to express their own sympathies. As a mark of respect, I ask that we all stand and observe a minute's silence, starting now. Thank you very much. Madam Registrar, would you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Guyana, hearing of consolidated appeals of GYCR number 1 of 2022 between Orwin, Hinds and the state, and GYCR number 2 of 2022 between Cleon, Hinds and the state. The members of this morning's panel are Mr. Justice Saunders, President and the presiding judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
Madam Justice Rajnatley.
Good morning, everyone.
Mr. Justice Barrow.
Good morning.
And Mr. Justice Burgess.
Good morning, Counsel.
May we have the appearances, please? Thank you.
Good morning, Your Honors. May it please Your Honors, Arudranath Gosai, I respectfully appear for the appellant Orwin Hinds in Criminal Appeal number 1 of 2022 and the appellant Cleon Hinds in Criminal Appeal number 2 of 2022.
Yes.
Good morning. May it please Your Honors, Diana O'Brien together with Mrs. Tashana Lake appearing on behalf of the respondent.
Yes, thank you. Mr. Gosai, are you ready to begin your arguments?
Yes, please, Your Honors. Your Honors, I start with the identification issue that was before the court.
Yes.
The first issue, I had divided the identification issue into sub-issues, namely a description of the appellant, the lighting circumstances, and the confused state of the eyewitness who gave the identification evidence. In relation to the description, Your Honors, the witness said this was a witness who testified at the preliminary inquiry, but unfortunately died before the trial in the High Court. And so he did not give viva voce evidence in the High Court. His statements to the police and the cross-examination in the preliminary inquiry form part of his evidence in the trial.
Yes.
In relation to the description, Your Honors, the witness in his first statement to the police, that is a statement at page 241 of the record, he said in that statement, he saw two persons enter the yard of his sister, the deceased person. He gave no description. He said one of the persons came up to him, lifted him off the steps, went into the house and began shooting his sister. He said that person was dark-skinned, was about 5 feet 7 inches, dark in complexion. The description of the other person, he said, it was a Negro man standing on the steps. He had on a bright color jersey. He did not get to see the pants color that he was wearing. That's at page 242 of the CCJ record. A year later, Your Honors, on the 26th of June 2012, the witness, the eyewitness, gave a further statement to the police. That is at page 249 of the CCJ record. In that statement, he gave certain evidence about lighting, which I will address as the second issue. But in relation to the appellant and the identification, the witness said, I look at their faces for about 4 minutes while speaking to them. But despite saying that, again, the witness did not provide any description of the second person, who, according to the state's case, would have been the appellant, Orwin Hinds, in this particular matter. Now, Your Honors, the respectful submission in that lack of description was that the Lorna trial judge should have directed the jury, or at least pointed out this fact and brought it to their attention, that the witness in the first statement gave no description of the appellant. The witness in the second statement, again, despite saying, I saw their faces, still did not give a description of the appellant. So respectfully, please, Your Honors, a direction to the jury to be careful of that part of the evidence of the eyewitness, that he saw the appellant, that lacking there is a description of the appellant, so may lend to the suggestion that he in fact did not observe or saw the appellant, because he gave description of the person who did the shooting. Now, the Lorna trial judge, in relation to the description issue, posed a question to the jury, and this is what the Lorna trial judge said. Is there a description of the second person?
What
Answer.
page is that?
Indulge me, Your Honors. One moment, Your Honors. Starting from page 285 of the summing up, page 285 of the CCJ record.
Yeah.
I'll get the exact quotation in a moment, please, Your Honor. At page 285, lines 31 to 32 of the CCJ record, and this is how the Lorna trial judge addressed the issue of lack of description. Did he ever give any other description of the persons? No. Did the witness, this is line 27, did the witness give a description of the persons? Answer. He only gave a description of the shooter as 5 foot 7 and dark in complexion. He did not give a detailed description. What he told the police,
you said?
of the record, yes, please, Your Honor.
That's 285 of 3.
Of
285
312.
310?
312.
Oh, I see. Okay.
That's 285 of 312 is the record in relation to Orwin Hinds.
I see. Okay.
Yes. 283 of 310 is the record in relation to the other appeal. So the learned trial judge was saying what he told the police was that he saw their faces properly, and if he saw them again, he can identify them. Respectfully, please, Your Honors, it is the submission of the appellant that at that stage, the learned trial judge should have alerted the jury of the lack of description of the other person. As I said, in the state's case, the state's position is that this other person was the appellant, Orwin Hinds. So we are saying that that was a fundamental misdirection or lack of direction by the learned trial judge in relation to a description. And in that regard, please, Your Honor, we rely on the cases of Henry and the state, 40 West Indian, page 312. That is at page 577 of the appellant's authorities.
What, counsel?
Yes, please, Your Honor.
Please tell me, what made it fundamental? He told them that there was no description given, correct?
Yes, please, Your Honors. But we're saying that the learned trial judge should have gone on further to identify the factors that the witness was saying he observed the two men for about 4 minutes. The later statement that he saw their faces.
Right.
Put to the jury that despite all of that, he did not give a description.
But with the greatest respect, what you are saying is he having told them, look, this witness did not give a description. What you are saying is that the trial judge should have, as it were, engrafted onto that statement of fact the significance that the defense is attaching to it. Is that correct?
That is correct, please, Your Honor.
Okay.
That is our submission.
But you would have told the jury that, I suppose.
Your Honors, I was actually not involved in the trial in the
Or you
High
went at the
Court,
trial. I see.
nor in the Court of Appeal, please, Your Honors.
But counsel, I
Yes, please,
have
Your
also puzzled over the matter. This lack of description is one thing, but is not the holding of the identification parade and the successful identification of the accused person at that parade, does that not take away any concerns, any argument you may have about the absence of the description?
Well, Your Honors, my answer to that respectfully is that the identification parade cannot in any way enhance or seek to give a different account other than what transpired at the time of the incident.
With the
So that, for
greatest
example,
respect, counsel, I cannot follow that at all. The fact that there was no description and the fact that there was an identification parade, if there is a disconnect between the two things, that is a matter of argument for counsel to the jury and for the jury to decide, well, hold on now. This man did not give a description and he later identified the accused. Do we believe his identification was authentic, etc.? Well, that's a matter of credibility, isn't it?
Yes, please, Your Honor. And I follow your argument that that could have been posited by defense counsel at the time of the trial today.
Okay, thanks.
To the witness, but there is no record. The style of recording the deposition in Guyana is a record is made, addressed to the jury, start at X time, ends at X time. No account of what is said to the jury. So I am strong in that regard.
But you see, Mr. Gosai, we also have to credit the jury with common sense. You know, they're the judges of fact, and having heard all the evidence, they were entitled to take the view that, well, he may not have provided any detailed description, but given how he gave his evidence, given the fact that he readily identified these people at the lineup, We believe him. So that was open to the jury. You have to convince us that the judge gave a misdirection and led the jury down a wrong path.
Now, interesting, Your Honor, in relation to that to that point, that there is absent any direction which could have been a positive direction by the learned trial judge to the jury in the same manner in which Your Honors are suggesting, that an ID parade had cured this lack of description of the appellant. But Your Honors, when Your Honors look at page 264 of the record, 264 of 269, and that is the identification parade, the form that is filled out by the officers who conduct and are present at the parade. And I'm looking at about 3/4 way down that form, how other persons on the parade were dressed, and that is blank. So that the identification, I jumped to that because Your Honors had raised the issue of whether the identification parade that was conducted could have cured the lack of description by the eyewitness at the time of the incident. But respectfully, I had an issue with the identification parade in terms of the form that was before the court, and that was part of the record that went before the jury. So if Your Honors look, for example, at the identification form, the identification parade form, in relation to the accused Roy Jacobs, in that is at page 261 of 269 of the record. And under the description, how other persons on parade dress, and in handwriting, the other persons on the parade were dressed similar, like the suspect. So I point this out to the court, please, Your Honor, that the ID parade itself had an issue on the record, on the face of the record. The accused in the cross-examination, in the number one appellant, in the cross-examination of the witnesses in relation to the ID parade, made suggestions that the persons on the parade were not of similar description, similar height. He was the only one who had tattoos, and those line of questioning of the witnesses for the state. So that to answer Your Honor's question as to whether the ID parade, the fact that an ID parade was conducted, could have cured that lack of description, my respectful answer is no, because the ID parade itself had issues.
Counsel, with the greatest respect, I have the utmost difficulty in seeing with that submission. For this reason, the identification parade was held, the identification was made on the holding of the parade. If the defense had a problem with the conduct of the ID parade, that was a matter which should have been addressed to the jury, and the jury should have been invited to say, do not believe this identification which took place at this parade because of factors A, B, and C. Therefore, jury, we say to you, completely dismiss that identification parade, place no reliance on the identification, and therefore treat this person as having been unidentified. That's a submission. That is not an argument. The ID having been held, the evidence having been given, is not an argument you can make to us, is it?
I'm guided, Your Honors. I'll move on to the next issue of the lighting. That's my submission in relation to the description. With regard to the lighting, please, Your Honors, given by the witness Fitzroy Feedcow, that's the witness who gave the ID evidence. In his first statement on the night of the incident, that is the 30th of June, 2011, and that's at page 240 of 269 of the CCJ record. At page 242, the witness said, "I could have seen their face properly. If I see them again, I could identify them. The light in the house was bright. Also, the light on the street was shining and reflecting in the yard." That's the extent of the lighting, the evidence of lighting given in the fourth statement. That is the statement of the night of the incident. Now, absent from that evidence is the fact that the witness did not say that the light in the house or the light on the street was reflecting on the face of the appellant. And in that regard, please, Your Honor, I am respectfully submitting that these are factors that the learned trial judge ought to have put before the jury for their consideration. The learned trial judge did give the jury the warning as prescribed in, as we call it, the Turnbull directions. But in the case of R.V. Daly, please, Your Honor, Daly and the Queen, similar facts arose in those circumstances. And the court held that giving the Turnbull directions is not sufficient in and of itself, that giving the directions is okay. But if there are particular circumstances arising in a case, the learned trial judge ought to identify these particulars and warn the jury accordingly. In Daly and the Queen, witness said she had observed 3 of the appellants, the accused persons in that case. There was light in the house, there was light coming from the outside. But at no time did she say that any of that light was actually reflecting on the faces of either of those persons. Similarly here, the witness at no time said, the witness story is that one accused person ran into the house and began shooting his sister. There was a fluorescent light in the house. He said the appellant, the other person, remained in the yard standing on the steps, and there was a street light reflecting in the yard. So, for example, the discussion in Daly and later in the case for Fuller and the State, that the learned trial judge should have pointed out to the jury that lacking from this lighting, that the evidence of lighting is only important insofar as it can assist in the identification. But in this case, you have light in the house and you have light in the yard. There's one person in the house and there's one person in the yard. The incident lasted for about 4 minutes, according to the witness. So which light was shining in the face of the appellant, for example? Daly and the Queen seem to suggest that these are directions and warnings. These are factors that the learned trial judge should highlight to the jury and then give a warning as to what weight they can place on the identification of the accused, giving the evidence of the lighting. We're saying respectfully that the learned trial judge did not do that. The learned trial judge gave the academic, quote unquote, with respect, Turnbull directions without going into the factors that may affect the identification and then give the warning accordingly. Now, Your Honors, on that point as well, a year later, the eyewitness gave a subsequent statement to the police. And in that statement, that is a statement of 26 June 2012. That's page 249 of 269 of the CCJ record. And this is what the witness said in this further statement. The entire area was very bright with electric lights from the Golden Brown Security Services that had external security lights on a light pole. Also, a 4-feet fluorescent tube was inside my sister hall, reflecting outside. Lights were also reflecting from the neighboring buildings. It's our respectful submission, please, Your Honor, that the learned trial judge should have done 2 things in relation to this for the statement, which embellish the lighting condition. That one, on the night of the incident, there was no evidence of any of the security services, light from buildings, what have you. But that even if they believe the witness that, yes, there were all these lights, as said a year later, still absent is whether any of these lights from the buildings, from the security services, was shining on the face of the appellant. So, yes, please, Your Honor.
But aren't you faced here again with the same thing, which we discussed a bit earlier? If the witness identified this person in an identification parade, then surely implicit in that is that the lighting was sufficient to have enabled him to perceive the features of the person that he subsequently identified. Otherwise, it is the case for the defense put to the jury, you cannot believe it was an authentic identification that took place at the parade. Once you cannot fault the ID parade, once you cannot exclude that, then he is properly identified. It doesn't matter what the witness said in an earlier statement or in a later statement, etc. The witness has identified the accused person, and unless you get rid of that identification, he remains properly, cogently, and fully identified.
Your Honor, respectfully, is the appellant's submission that even if that particular aspect of the witness's testimony or evidence was not highlighted to the jury by defense counsel, that the learned trial judge, having embarked on a warning in relation to the Turnbull directions, was directing the jury that this is the things that you have to look for in relation to making up your minds whether you believe the witness. So that having embarked on an Turnbull directions, the submission of the appellant is that don't just leave it as a generic submission. Identify in the Turnbull directions those factors which the jury must consider and point to the jury the evidence in the case on which the factors exist and the warning that should follow. So that the learned trial judge, even if defense counsel did or did not, the learned trial judge, having embarked on a Turnbull direction, ought to have gone further and, in other words, subdivide the Turnbull directions by identifying the various factors, lighting, description, etc., and giving the jury the appropriate warning. That's the respectful submission of the appellant in relation to that.
I want to assure you, I have that perfectly clear. You have done a great job in projecting that, in conveying that, in expressing it. You have not gotten past the fact that even if the judge was deficient, derelict in giving directions that you say he ought to have given, even if the judge failed to highlight things which would tell in favor of the accused person, the fact of the identification parade and the factual identification of the witness really knocks your argument in the head.
I understand what your honors are saying in relation to the ID parade, but I repeat the submission respectfully that the ID parade could not in any way respectfully change what the witness said or observed at the time of the incident. But
I have done my best to convey to you the areas which are troubling me, and I think I need do no more.
Thank you, Your Honors. Your Honors, I will address the court on the issue of the confused state of the witness. Of course, the ID issue may arise here, but in relation to the confused state, I make the same argument, please, Your Honor, submission, that the witness in his cross-examination in the magistrate's court indicated that at the time of the incident he was confused, that he got sick after the incident after the shooting. That's at page 256 of the CCJ record, 256 of 269. Now, again here, Your Honors, this issue of the confused state of the witness, which the witness himself gave evidence in the magistrate's court, was not highlighted to the jury. In that regard, we rely on the case of Barnard and the Queen in relation to the direction which a Lorna trial judge ought to have given the jury in relation to a witness confused state. Now, that is entailed in the Turnbull directions, but we're saying in this case, there is a specific element of that evidence of a confused state given by the witness himself. And the Lorna trial judge, of course, again, did not highlight that to the jury in directing them or warning them to be careful in acting on this identification evidence. So, Your Honors, those are the submissions of the appellant in relation to the identification evidence. Our submission in a nutshell is that the directions were woefully inadequate, did not identify to the jury the factors which could support the accused story that he was not there at the time of the incident, and that the witness may have been mistaken in his identification on the night of the incident of this appellant. The next issue, Your Honor, is the issue of the alibi defense that was led by the appellant Orwin Hinds. At page 202 of 269 of the record, the appellant said that on the night of the incident, well, from the afternoon going into the night, he was with his girlfriend, Adele Campbell. Adele Campbell gave evidence at page 203 to 205 of the record that the appellant was with her on the afternoon and evening of the incident. Page 204 of 269, the evidence of Adele Campbell continues. She said that the appellant did not leave her side and he was with her all the time until they went home around 8 p.m. In relation to the direction to the jury, please, Your Honor, with the alibi defense, the Lorna trial judge at page 309 of 312 and this is what the Lorna trial judge said to the jury in relation to the alibi defense. Starting at page 308, line 32. The Lorna trial judge says, let us first consider the defense of Orwin Hinds. In his unsworn statement, he's saying he does not know anything about the incident. He was with his girlfriend. He called Adele Campbell, who testified that she at the time was his girlfriend and that he was with her on the evening of June 30th, 2011. You will consider that. And then the Lorna trial judge goes on to give an assessment or an analysis of what the state was making of Adele Campbell's evidence. That's at page 309 of 312 of the record, lines 8 to 19. Telling the jury, for example, that the state is saying you cannot believe Orwin Hinds because he's changing his story to fit whatever allegation is made at the time. Like, for example, he lied about his cell phone. The state is saying the accused never called Adele's name, never said she was his girlfriend, and that in their opinion, Adele was a witness of convenience. And then he explained what a witness of convenience is. And then at line 21 on page 309, please, Your Honors, the judge said to the jury, members of the jury, this is a matter of fact for you to determine whether you accept her testimony or whether or not you believe and accept Orwin Hinds. Based on what he's saying, if you believe him or whatever he said, and the defense raises a doubt in your mind about his guilt, you should return a verdict of not guilty. Just be clear, it is recorded here, just be clear, they have to prove things beyond a reasonable doubt. Once you believe them, that's enough. Now, that sentence seemed to suggest that the learned trial judge may have said to the jury that the accused does not have to prove anything beyond a reasonable doubt, or that the state had to prove things beyond a reasonable doubt. But the sentence as it is, we're saying whether the learned trial judge is saying the state had to prove things, or that the beyond a reasonable doubt, or that the appellant did not have to prove things beyond a reasonable doubt. That the learned trial judge, that leaving the direction on the alibi as is would seem to suggest, or at least the jury may have gone with the impression that if we don't believe him, then he's guilty. We respectfully submit that the learned trial judge should have gone on to tell the jury that if you believe him, as he did say, or you have a doubt, you must find him not guilty. But if you don't believe him, you have to go back and assess the case for the state to determine whether they have proved the case against the appellant. That particular direction is lacking from that part of the summing up and that warning given to the jury in relation to the alibi. And we're saying that that was an error made by the learned trial judge. In that regard, Your Honor, we rely on Barnard and the Queen, 45 West Indian 296, and the state against Ori and Passad, 25 West Indian 201. The Court of Appeal on this issue, please, Your Honor, please, Your Honors, on the alibi, the direction on the alibi issue raised by the defense of alibi. Indulge me, Your Honors. At page 24 of 27 of the CCJ record, lines 16 to 23 is where the Court of Appeal addressed the issue of the alibi defense, essentially saying that once the judge would have said to the jury throughout the summing up that the burden and standard of proof remain on the prosecution, that there was no express need or any need for the trial judge to, when he's dealing with the defense of alibi, to go on to give that extra warning, as we call it, in relation to if they disbelieve the appellant's story on his alibi defense. The Court of Appeal rely on a case of Adams and Lawrence from the Guyana Court of Appeal that was decided in the year 1967. But we respectfully submit, Your Honors, relying on the recent cases of London and the State, 57 West Indian 424. That's at page 669 of the appellant's authorities. And the case of the Queen against Gavaskar Brown, 62 West Indian 234. That's at page 671 of the authorities, essentially stating that the extra warning or the additional warning to the jury that if you don't believe the accused person on the alibi defense, you still have to go on to consider, if you don't believe him, whether the state has proved the case beyond reasonable doubt. That's saying that repeating the burden and standard of proof in the summing up is not sufficient in relation to dealing with the alibi defense by itself.
Mr. Gosai,
yes, please, Your Honor.
At the end of the summation on page 309 of 310, the judge said, in closing, if you reject an accused defense, or even if you find that an accused defense was weak and it do not make sense, do not convict him based on that rejection or finding of weakness. You must go back to the state's case, ask yourself, are we satisfied to the extent that we feel sure that the state has proven to us that this particular accused has participated in this common plan and therefore is liable in this crime. Is that not exactly what he should have said, or is it your contention that he should have said that right after he analyzed the alibi?
That is our respectful submission, please, Your Honor, that the warning given at page 311 of 312, I believe Your Honor was quoting the page in the other appeal,
sure,
that is the warning that should have occurred immediately after the alibi defense, because this was a case, importantly so, because this was a case of 4 accused persons. And so having gone through the defenses of each, at the end, the law and the trial judge say, well, if you reject any of the defenses, you go back to see whether the status. So that is what we're saying in relation to the appellant having raised the alibi defense. That warning should have occurred at the time the warning was given as to how to treat with an alibi defense.
So,
yes, Mr.
You could also reason, if he had said it right away, then by the end of his long submission, they might have forgotten. So maybe it's better to say that at the end, to stress that in general, if you reject a defense, don't be satisfied with that. Go back to the state's case and see if you really think it's proven. So I'm not so sure if it should be done right after every defense. But anyway, you seem to think that is so.
Your Honor, is that another question of me?
Yes, I was asking if you thought, Mr. Gosai, that by itself would make the conviction unsafe?
Not that by itself. No, please, Your Honors, because there was other evidence before the jury on which whether they rejected the alibi defense or not could have, being properly directed, arrived at the same verdict. I move on to the issue of the confession statement, please, Your Honors. In relation to this appellant, page 200 of 269 of the record, he gave an unsworn statement from the dock. And in that statement, he said that the police, that he signed the statement as a result of beating by the police. And his allegation of being beaten by the police, in fact, he said at one stage, one of the police, that is at page 200 of 269, he said, as he leaned back in the chair, I barely turned and see Sarabo lash me in my head. When I catch myself, I was feeling severe pain in my head. I could feel a bump there, and the witness pointed out the right side of his head. Now, this allegation of that injury to his head was supported by a witness for the state, David Hunt. David Hunt is at page 201 of the record. Sorry, Your Honor.
Could we agree, Mr. Gosai, that the existence of the bump was amply supported by a number of witnesses? And as well, could we agree that there is merit in your complaint that the judge, in telling the jury about those who supported the existence of the bump, omitted to mention the girlfriend's support of the bump in the summing up? So we are very clear on all of that.
Thank you, Your Honors.
Okay.
Right.
Next.
So the next point I make on that is that in the direction to the jury, the learned trial judge seemed to have suggested to the jury that the accused could not explain when he got that injury and whether he got that injury at the time he made the statement. We respectfully submit, Your Honors. That's at page 300, 301, 301 of 312, lines 1 to 12. In directing the jury on the issue of the confession and the injury that the accused complained of, the learned trial judge at line 11 said line 9, the state is saying that Garnett told you he did not see any injury when he was taking the statement. And Simeon Reed told you he saw no injury while he was conducting the ID parade. Therefore, this injury cannot in any way be related to Orwin Hinds and the giving of the caution statement. Now, respectfully, Your Honors, that seemed to have suggested that the appellant is complaining of an injury received while in police custody, and the judge seemed to be suggesting it is for the accused to establish when, where, who inflicted that injury. When in fact, Your Honor, it ought to have been the other way around, for the state to satisfy the jury beyond a reasonable doubt that the injury complained of by the appellant was in no way, shape, or form the reason why the appellant signed the confession statement. That direction was missing from the law and the trial judge's summing up. And we're saying that that was fundamental enough to set aside the appellant's conviction. Absent the ID evidence, if the confession statement is excluded, there is no other evidence to connect the accused to the commission of the crime.
Mr. Gosai, I examined your submission in relation to the confession, of course, very fully, because the proposition that you just put, absent the confession, there is no other evidence to connect him to the commission of the crime. I think you can put it the other way. Given the confession, he has no chance of succeeding on the appeal. Therefore, it seems to me, the matter of the voluntariness of the confession is the make or break point for you. But your focus is on this bump. You have spent a lot of time on the bump. But the analysis which occurs to me is that this bump would be, as it were, corroborative. It would be supportive of the proposition that he was beaten. So the existence of the bump is in itself of no more significance than that it can stand to confirm, to support, to make credible the statement that he was beaten.
Yes, please, Your Honor. That is the.
So let's not over, as it were, emphasize the evidence in relation to the bump. The question is, did the jury, given the fact of this bump, did the jury accept that this indicated this man was beaten to give the confession?
Well, we're saying respectfully, Your Honors, that the learned trial judge putting the direction to the jury in a similar manner that Your Honor was just suggesting. The bump by itself is just supportive that he was beaten. And so they have to then decide whether the confession was given by the appellant as a result of this beating, which, quote unquote, is supported by evidence of injury. But the learned trial judge did not do that. The learned trial judge seemed to say, well, the appellant did not explain how he received these injuries, when it should have been that the state had to prove to you, beyond a reasonable doubt, that the appellant did not receive any beating. And as a result of the beating, that led to him signing the confession statement. That is the manner in which the appellant is submitting in relation to the allegation of him being beaten by the police to extract that confession.
Mr. Gosai, would it be
yes,
possible just to take us back to what the learned trial judge actually said to
yes,
the jury on that issue? Thank you.
So for completeness, please, Your Honors, I'll start at line 1 on page 301 of 312. Orwin Hinds told you about the right side. They are saying in any event, taking her evidence and the evidence from the defense, they cannot establish when this bungi came about on the head. Bungi is Guyanese parlance for a bump on your head, please, Your Honors. If it was at the time of the caution statement being taken before or after, the state is saying to you that Hunt told you that he would not even have noticed the bump unless he was told to examine Orwin Hinds. And Combermack told you that she could not say how long before or when that injury would have occurred. The state is saying to you, consider that Garnett told you that he did not see any injury when taking the statement, and that Simeon Reed told you that he saw no injury while conducting the parade. Therefore, this injury cannot in any way be related to Orwin Hinds and the giving of the caution statement. So respectfully, Your Honors, the learned trial judge was drawing a conclusion for the jury. That is a question for the jury to determine, having gotten the proper direction in relation to the evidence as to what weight they will place, if any, on the caution statement of the appellant. But the judge, in fact, drew a conclusion for the jury.
Sorry, could you take me to that particular passage again, where he drew the conclusion?
The state is saying to you, sorry, Your Honor.
What page number is it?
301 of 312 of the record.
And what line are you at now, Mr. Gosai?
I'm going to read from line 9.
Thank you.
Yes, please, Your Honor. The state is saying to you, consider that Garnett told you that he did not see any injury when taking the statement. Simeon Reed told you that he saw no injury while conducting the parade. Therefore, this injury cannot in any way be related to Orwin Hinds and the giving of the caution statement.
Sorry, and you are saying that's a direction being given by the judge?
No, please, Your Honor. We are saying that the judge was drawing a conclusion for the jury.
But with respect, counsel, could that not also be read as the judge saying what the state is saying? That's why I read it.
So did I, my brother. Well, that's how I read it.
I see what Your Honor is saying is that it occurs in the same paragraph.
In which he is summarizing what the state said.
Indeed, Your Honor, indeed. So it could lend to that. It could lend to that interpretation, and not mine, as I suggest, was a conclusion by the learned trial judge. Those are the submissions of the appellant, please, Your Honor, in relation to the evidence and the summing up. I will address Your Honors, unless Your Honors wish to hear from the other side on the issue of sentencing.
Yes, you could address us now on the issue of sentencing.
Very well, Your Honor. Your Honors, when the appellant would have submitted its written arguments on the issue of sentencing, at that time, we did not have the benefit of this court's recent extensive guidance in the case of Gopal and the state in relation to the sentencing. In Gopal and the state, the accused persons, in that case, the appellants, were sentenced to 106 years and 96 years, respectively. That is small, 96 years, Gopal, 106 years. And this court held that sentence of 106 years and 96 years was grossly disproportionate and manifestly excessive. The Court of Appeal in the Gopal case had reduced the number of years to 45 years. And this court again had ruled that the 45 years was not grossly disproportionate, but still was manifestly excessive. We submit, relying extensively on the guidance provided by Justice of the CCJ Jamadar, and say that in the instant case, the imposition of 81 years by the trial judge was grossly disproportionate, to use the words of Justice Jamadar. And the 50 years imposed by the Court of Appeal in this case is manifestly excessive. Now, Your Honors, unlike the Gopal case, where there was a statutory minimum starting point of 15 years, the appellant here was charged under Section 100, subsection 1, paragraph D, subparagraph 1 of the Criminal Law Offences Act, which provides that the penalty for that offense is either death or life imprisonment. the Lorna trial judge and the Court of Appeal seem to have imposed a term of years, because neither the Lorna trial judge nor the Court of Appeal used the words life imprisonment. The extensive guidelines provided by Justice Jamadar, we say, is equally applicable in this instant case, save and except the guidelines in relation to a statutory minimum, because there is no minimum number of years in this particular case, either life imprisonment or death. And we submit that despite the fact that there is no statutory minimum, having reviewed the guidelines provided by Justice Jamadar, that a starting point of 15 years would be reasonable in the circumstances of this case. And we submit further that, save for the use of a firearm, there were no other aggravating, and for that the murder was for money, there were no other aggravating circumstances, or there are no other aggravating circumstances, that while there will be an uplift to the 15 years in relation to the use of a firearm and murder for money or murder for pay, that respectfully a sentence in the circumstances ranging from between 15 to 20 years is reasonable in the circumstances, please, Your Honor. Those are, sorry, Your Honor.
Do you believe that in a case of joint enterprise, that each participant must invariably get the same sentence?
The answer to that will be no, please, Your Honors, because the evidence may unfold that despite the fact that there's one charge of joint enterprise, all four are equally liable, as in this case, that there may be participation by one in the actual commission of the crime, while another, for example, may not have participated in the commission. As in this particular case, the appellant's case was that he stood outside. He had said to them he's not taking part in this, but he was there. The Dutchie, as he's called in the proceedings, is the person who shot and killed the deceased. So that the answer to Your Honor's question is that in those circumstances, the court may use a discretion to impose a lesser sentence for an accused in a joint enterprise who does not, in fact, take that step to cause the death of the deceased.
Counsel, let me
Yes,
ask you,
Mr.
the matter of life imprisonment. Why would you say life imprisonment would not be appropriate in a case such as this in relation to Orwin, even if there's a distinction drawn in relation to Cleon? Why not life for Orwin?
Your Honors, if Your Honors are considering, for example, a life imprisonment, in the Guyana,
we are considering all things which we should
please,
consider.
Yes, please. That I would still submit, please, Your Honor, that in relation to the question whether life imprisonment for Orwin Hinds and maybe a different sentence for Cleon Hinds, my answer to that is yes, the court can consider two different sentences. In relation to life imprisonment for Orwin Hinds, my submission in that regard would be, if the court were minded to go along that line, that some definition, as this court did as was done in Alain, for the Barbados context, as what can be considered life imprisonment, that a similar exercise be done for the Guyana context. Because in Guyana, we don't have a definition of what constitutes life imprisonment. So that is my answer to that.
But do you need a definition? Life imprisonment means life imprisonment. But of course, we know that in terms of sentencing policy, in terms of the parole board, etc., it would be in the rarest of cases that the consideration or in fact the granting of parole would not occur. So the question for you really is, why should not life imprisonment, given that parole is a factor, not be considered in Orwin Hinds as possibly, that's all I say, possibly an appropriate case for life imprisonment? What arguments are there against life imprisonment?
Well, thank you, Your Honors. In relation to Orwin Hinds, the state's case, which is part of the confession statement by Orwin Hinds, was that on the day of the incident, he had indicated to the other accused persons that he is not part of this. This is not my thing. Words to that effect in his caution statement. And when they arrive at the scene, he had said, Dutchie told him, let's go in the yard. And he had said, I'm not going in there. That's not my thing. He then said, when he arrived in the yard, Dutchie asked him to hold on to the eyewitness. Again, he said he refused to do that. He said, me and this is how you think, do what you're doing. So that to answer the first question as to whether the equal sentence be passed on each participant, my respectful submission would be in relation to Orwin Hinds, that while he may not be considered an innocent bystander, that he had indicated he was not going to play a part in the actual killing of the deceased person, so that if any discretion can be exercised, it may be in regard to his quote-unquote non-participation in the actual commission of the act which caused the death of the deceased person. And so in those circumstances, yes, please, Your Honors.
Yeah, the problem I have here, as I have very often when sentencing is carried out in the manner in which this one was done, I don't know anything about Orwin Hinds. How old is he? Does he have children? What are the factors that produced this kind of person? Does he, what do the people he lives with say about him? There is nothing of that. We don't know. Presumably the trial judge didn't know either. And so can you really sentence someone in ignorance of all of those factors?
And my answer to that, please, Your Honors, is no. And that is why Your Honors had stated in the Bibi Gopal Jarvis Small case that the judge should have conducted a sentencing hearing. So like in Gopal case, similar in this case, jury returns a verdict. And in relation to Orwin Hinds, this is at page 219 of 269 of the record. All that is said, this is what is said by Orwin Hinds. I'm innocent of this charge. And then his counsel says he's first time before the court. Today is his birthday. That is the extent of what was said on behalf of Orwin Hinds. And the sentences flow thereafter. So respectfully, we agree with Your Honors that these are cases where a sentencing hearing ought to be conducted. And we hope that the courts in Guyana, following the guidelines as they are mandated to do in the Bibi Gopal and Jarvis Small case, will in the future conduct such sentencing hearings so that when the matter reaches before Your Honors, there are factors which Your Honors can consider.
One other question.
Yes, please, Your Honor.
We, of course, will ask the director, should this case be sent back for sentencing? Just a thought. So that these considerations can be explored. A sentencing report prepared, we learn about the antecedents, etc., the things which the president raised, etc. I'm simply raising the question, not proposing it.
I respectfully believe that that would be, if the court reaches that sentencing stage, that would be an appropriate direction to give, because High Court had no such factors. The Court of Appeal had no factors, and were Your Honors to impose a number without those factors would, respectfully, in my view, not assist the jurisprudence going forward in relation to sentencing, so that a sentence hearing can very well be ordered to be conducted.
Just
Thank
one
you,
last
Counsel.
thing. If the court were to impose a life sentence, is there is it permissible in light of the Parole Act for the court to further impose a time period beyond before he can be eligible for parole? Can the court, for example, say, I sentence you to life imprisonment, but you can't be eligible for parole for 30 years or 25 years, or as the case may be? Is that consistent with the Parole Act?
Your Honors, any parole that the board will have to consider in a life sentence will have to be in accordance with what the legislation provides.
Right.
I must say, Your Honors, that I have not looked at the Parole Act in relation to,
no,
but whatever.
Yes.
Yes, please. So that the court may very well do that. But let's say, for example, the Parole Act says not before 15 years. Respectfully, I do not believe that the court can go below 15 years.
I think in this case it would be 20 years. You refer to Gopal. That reasoning cannot be fully applied, I think, in this case, if it ever comes to that. Because in that case, the maximum was sentenced to death, sentenced to imprisonment for life, or such other term as the court considers appropriate, not being less than 15 years. That was in that case. In this case, there is only a choice between life or death, sentence to death or to imprisonment for life. Of course, now we have the difficulty that two others who have not appealed got, I think, 50 years. But that is a restriction to what we can do. I'm not sure, but the Criminal Law Act more or less limit our possibilities in that respect. Maybe this is a clear sign that the law should apply some more flexibility, because it's very difficult to take into account all the relevant factors if you are so bound by an act of law. But so that is a difficulty I gather. Anything you want to say to that?
Well, I believe, respectfully, Your Honors, that I'm not aware of a case coming from our jurisdiction in relation to an interpretation or an assessment or an analysis of the Parole Act and whether, for example, it may be unconstitutional in terms of the number of years before you're eligible to parole. But I understand what Your Honors are saying, that in this particular case, the court would be limited in relation to applying the law as it is now, vis-a-vis the Parole Act and the number of years in which a person may be entitled to parole.
Mr. Gosai, if I may,
yes,
on a slightly different matter. I know that in Gopal, certainly the court spoke about the need for separate sentencing, hearing, and so on. But I had thought, since at least Ramcharan and perhaps even Pompey, I haven't gone back to look at those recently, this court was speaking about the necessity to hear not only about the history of the defendant, but of the impact that this has had on the victims' families. Of course, in Pompey and Ramcharan, we were actually speaking about the victims of rape. But we are here speaking about a lady who was struck down and so on. So I'm interested to know, Mr. Gosai, from your own experiences, from your experience in the courts in Guyana, have the trial judges started to do sentencing hearings, and have they been listening and ordering victim impact statements and the like?
In some cases, yes, please, Your Honors. Recently, there was a case where the accused persons were sentenced to death. A sentencing hearing was, in fact, ordered, probation report, and the like. But in terms of a general holding of sentencing hearings, that is not the position in Guyana. Some judges do, and some judges don't.
Well, it would just appear from my screen that your colleagues on the other side may not agree with you, and I'm sure we will hear more from them. Thank you anyway, Mr. Gosa. I'm glad to hear that in that case there was indeed a separate sentencing hearing. Thank you.
Yes, please, Your Honors.
Let's take a 10-minute break, and then I would call on the representative from the DPP's office to give her response.
President, I'm not seeing Justice Barrow and Burgess. Are you seeing them from on your side?
Justice Burgess is here.
Yes.
Justice Barrow is shortly going to be here.
Thank you, sir.
Would like to hear you on the conviction appeals only in relation to any particular issue that you particularly wish to raise. Other than that, we would hear you on the appeals against sentence.
May I please, Your Honors? There is no particular issue we would like to raise on the conviction. We would rely on our submissions to that. On the issue of sentencing, the state respectfully submits that, as this court is aware, our submissions were in before we got the decision in Jarvis Small and Baby Shirima Gopal. And using that decision, the state submits that the sentence for this category of murder is death or imprisonment for life. But section 103A, which is on page 405 of the submissions of the record, please, or Hinds record. It says at 103A, where the court imposes a sentence of imprisonment for life pursuant to subsection 1A, and subsection 1A is the murder in this category of offense. The court shall specify a period being not less than 20 years.
Okay, so that the court does have some flexibility in determining the period before you can apply for parole.
For parole, yes, please, Your Honors. And
okay.
Using this section and the decision, the state would respectfully recommend that when we take into consideration the statutory minimum, maybe a reasonable starting range may be 20 to 30 years. And this will ensure that the murders in this category will not attract the same sentence as the murder in Baby Shirima Gopal case did. And we're suggesting this starting range so that there would be a consistency in the methodologies and the approaches for sentencing, please, Your Honors.
But
Your
Counsel,
Honor,
sorry, may I?
yes, please, Your Honor.
Yeah, you are advocating a fixed term rather than a life sentence. Is that correct?
No, please, Your Honors, I'm not advocating for a fixed term, but what I'm saying that if a life sentence is granted by this court...
No, I gather that. I'm clear on that, yes. There's a 20-year minimum.
Yes, it's a statutory minimum, but I'm not advocating for a fixed term, please, Your Honors.
All right, taking it further then, and you think that Cleon and Orwin should both receive a life sentence?
Yes, please, Your Honors. Your Honors, I know in certain cases on joint enterprise, when you're sentencing, you sentence based on the roles of the different appellant. But in this case, please, Your Honors, in relation to the roles that they play in that they provided the weapon for the murder, the state is respectfully submitting that the sentences ought not to be differentiated. And maybe that's why the lower courts did not differentiate the sentences, because Section 24 of our Criminal Law Offences Act states that we sentence each party to the offense as we would the principal. So I'm not sure if it's because of, not that I'm not sure, I'm sure because of the role that they play in providing the weapon, that's why the state is asking for their sentences not to be differentiated.
Well, it's just permissive. It says everyone who comes an accessory before the fact to any felony, whether it is a felony at common law by virtue of any written law for the time being enforced, may be indicted, tried, convicted, and punished in all respects as if you were a principal felon. So I don't think that there is any compulsion to give the same sentence to every accessory before the fact. It's just that it is possible that you can get the same punishment as if you were a principal felon.
Yes, please, Your Honors, it is permissive, may, but in this specific case, we're asking for them to get the same sentence because of the role they played in the murder.
I see. Cleon is the one who provided Cleon is the one who provided the weapon.
Both of them provided the weapon, please, Your Honors. When they were approached, when the first brother was approached, he contacted Orwin and they both agreed to provide the weapon. It's just that Orwin got further involved in that he actually got into the planning of the execution of the murder.
But that is that therefore, counsel, not a basis for distinguishing between their sentencing? I am not, again, advocating, simply raising. One, in fact, went along to participate. Mr. Gosai says he was reluctant at all stages, but one, in fact, went along, the other did not. Is there therefore not a different degree of criminality, a different degree of moral turpitude in relation to that scenario?
Your Honor, the issue that the state is having with giving them the differentiation in the sentencing is the fact of the provision of the weapon.
Well, if I may, just for the sake of argument, it occurs to me that in terms of providing a weapon, the seller, the licensed seller of a firearm provides the weapon, just that he does not provide it for the purpose of a crime, and he does not provide it for it to be used in relation to a particular victim or a generally described or ascertainable victim. In this case, the provision of the weapon is obviously what makes them liable as accessories, etc., and where their conviction, if upheld, is properly upheld. But certainly, it seems to me that there is, nonetheless, a distinction between somebody who provides a weapon and somebody who pulls the trigger.
If I have to caution statements, then both accepted the money. So that is, of course, also a sign that maybe one of them might have been reluctant, but he was at least not reluctant to receive the recompensation for what they did. On the other hand, if I would believe those caution statements, then there's even a more wicked person in play, namely somebody who was in a dispute with the and who to have her killed, offering money. Now, that person is totally absent in this story. I was just wondering if any investigation was done to find out whether there was a dispute and who was involved in this dispute, just to get a background information. It also is important, of course, when we talk about rules that may have an impact on sentencing. For example, one of them, not the Hindses, apparently had the money to give to them. And if the amount of money was, I think, 1.2 million, he had 100,000 to give to them, according to these statements. Well, that is also something of significance. So the question is, was any investigation done in that respect or not? And another point is that, okay, if we now say that, well, actually in a crime like this, the choice is between life and death, life imprisonment and death, and then you say, well, then you should give them life imprisonment. How does that relate to the two who actually the one who used the arm and did the killing and got 50 years?
Your Honors, in relation to the investigation about who hired them, there was an investigation that was done in this matter. However, the investigation did not lead the police to who authorized the killing, but we have all the information on file about the land transactions and so forth.
Okay.
In relation to the two other appellants, the two other accused persons with these appellants, one of those appellants has died, and the other remaining appellant who is sentenced to 50 years, please, Your Honors, I believe his sentence would have to attract our Parole Act, because once prisoners are of good behavior and so forth, they're granted remissions on their sentence. So if he is a model prisoner in prison, his sentence should be far less than the 50 years as directed by the court.
I see. And who is the one who died?
Kevin October.
Thank you.
I'm a little confused about remission and parole. To me, they're two different things. That remission is where, if you are of good behavior, each year is counted, each calendar year is counted for 8 or 9 months. But parole is where you come before a parole board if you're of good behavior, without prejudice to remission, and the parole board may grant you parole. Am I correct?
Yes, please, Your Honors.
Okay. Is there a minimum period before October can get parole? Sorry, October is the one who died or the one who is still alive?
October is the deceased. Roy Jacobs is the one who's
Sorry,
alive.
Jacobs, yes. Is there a minimum period before he can get parole?
There is not a specified minimum period, but usually when they're deciding to grant parole, we most times get those files after 15 years, please, Your Honors. The parole board usually sends to the DPP for an opinion as to the facts and circumstances of the case. We usually get that after 15 years of imprisonment.
That's a matter of practice. There isn't anything
Yes,
in
it's
the
a matter
statute.
of practice.
I see. Okay.
But if I understand it well, he was also convicted for murder for pay. Let me put it that way. So he should then have gotten either a life sentence or a death sentence. Well, let's forget about the last one. So then he would have had an opportunity for parole after 20 years, as I understand it. So it would be strange if, because he got 50 years, he now gets an opportunity to get parole after 15 years. It would seem to me that is awkward.
But Your Honors, in this case, if such a request is sent to us, it would be incumbent upon us to give them the correct information and guide them to the section that it is 20 years here for this type of offense.
Okay, and you have a parole act?
Yes,
and you have a functioning parole board?
Yes, please, Your Honors.
Since when, if I may ask?
It has always been there. It has always been there, please, Your Honors.
Oh, okay. And that board is, how is it constituted?
The Constitution is divided by the legislation, but most times there is a retired judge that is on the panel.
I see.
That chairs the board.
Okay. Thank you.
Yes, Counsel, is there in Guyana any case you can direct us to where we can see how the parole board functioned? Any matter dealt with either in the High Court or the Court of Appeal that might be of some assistance to us?
I'll check for it, please, Your Honors. I can't think of one offhand at the moment.
Thank you. I appreciate that. Thank you.
So,
similarly, Mr. Gosai.
Yes. So, Counsel, what is your suggestion as to what the court should do in relation to the sentences?
Well, my first submission, if the court is following the guide, how it was lotted out in Nisogopal, I had recommended a statutory minimum of a starting range of between 20 to 30 years. However, if the court is considering a life sentence, I would also, I would prefer the court to give a life sentence, bearing in mind the statutory minimum for parole, please, Your Honors.
And what is your view about having the whole issue of sentencing be remanded to a trial judge?
Your Honors, we do not have legislation in Guyana that allows for it to be sent back to the trial judge. I understand the difficulty that the court faces in that there is not sufficient information before the court for the court to exercise its sentencing discretion, but I would rely on the opinion of Justice Jamidari Nisogopal when he said because of the length of time that has passed between the trial and the sentence to the appeal, that the court was sentenced based on the information that they currently have before them.
And the trial concluded when? Is it 2015 or 2016? 2015. 2015, 7 years.
And the occurrence was what, 2010 or 11?
2011.
So 11 years now. Okay.
Okay. Is there anything further that you wish to urge in relation to sentencing?
Yes, please, Your Honors. Just would like to inform the court that since we got the decision in Linton Pompey, the court has been doing sentencing hearings in all the cases. The only challenge we have had is that because of how our mental unit is staffed, we have some issues with getting psychological evaluations. But we have been doing sentencing hearings in all the matters, murders and rapes, please, Your Honors.
Okay. Is that all that you wish to urge at this time?
Yes, please, Your Honors.
Okay, thank you very much. Mr. Gosa, is there any response that you wish to make?
No, please, Your Honors.
Okay, so we take another short recess and then we'll come back to you. Okay, we've reached a decision in this matter. The appeals against conviction are denied, and we would reserve our decision on the appeals against sentence, and we will give a written decision giving our reasons for not upholding the appeals against conviction and for the decision we ultimately give in relation to sentence at a date to be communicated to council. So a suitable order will be given to the parties, if not today, certainly by tomorrow, which will encapsulate what I've just said.
Grateful, please, Your Honors.
Thank you,
Yes.
Your Honors.
Thank you. Madam Registrar, can you please close the proceedings?
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Madam Justice Rajnath-Lee. Thank you, Mr. Justice Barrow, and thank you, Mr. Justice Burgess. Thank you, Council, and a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day. Thank you.
Thank you.